Washington Arbitration Week. I will make this very, very short. Apart from saying thank you very much to Allen Overy and everyone that is sitting with me, I must say a couple of things about our moderator. This is a panel that was. This is the first time that we have a panel on life and sciences at Washington Arbitration Week, and this is mainly because of Patrick Pearsall's and Guy Lagering-Flores initiative. We basically thought, what would be innovative, what would be important in terms of growth of arbitration in a specific field. And there you go. They raised their hand and said, well, we must have a panel on life and sciences because of the steps and the growth in general in international commercial arbitration, but not only that, in investor state arbitration, etc. Simply allow me to say that Patrick is the leader of international arbitration at Allen Overy in Washington, D.C. He has extensive experience in representing parties in international disputes and providing strategic advice on asset protection, global investment, and commercial contracts. He served, importantly, in the U.S. State Department for nearly a decade, working on economic and natural resources diplomacy, and departed as the chief of investment arbitration. In addition to his representations, Patrick was on a drafting committee for the revision of the International Court of Arbitration's rules and led the negotiations of several bilateral, multilateral treaties. He advised on the negotiations of the investment provisions in the Trans-Pacific Partnership (TPP) and the Transatlantic Trade and Investment Partnership and the U.S.-China Bilateral Investment Treaty. He has received several awards and serves on multiple boards. He's also an adjunct professor at Georgetown. He has been in several, or he is part of several arbitration centers, and lately he has also been involved in various representations related to life and sciences. Thank you, and with you, our moderator.
Thanks, Jose Antonio. I think this mic is working. Welcome to everyone in the room and online. I really appreciate you tuning in the Monday after Thanksgiving. And for those of you watching it in a recording, it is the Monday after Thanksgiving where we are. And we're very grateful for everyone to be here. We have what we hope is a pretty exciting hour and 10 minutes or so for you today. We're going to be talking about life sciences. And for those of you who are a little bit confused or questioning what are life sciences, what is life sciences, how does it relate to international arbitration, that's the purpose of the panel. So thank you, Jose Antonio, for your invitation to us all. Washington Arbitration Week has become a can't miss moment on the arbitral calendar, and your willingness to pursue new areas that have not been discussed is very much appreciated, and life sciences is one of those. He mentioned, Jose Antonio mentioned growth. The reason we're here is because we see life sciences as a particularly important growth area in international arbitration, something along on the order of, and we are just starting to get some statistics on this, around a quarter of cases currently at the ICC, for example, relate to some IP issues. So that's pretty significant that a quarter of the cases right now have IP adjacent or IP related issues. I think that is only going to continue. So we're going to talk about it. What is it? What are the rules? Why does it matter? How do clients implement them in their deals? And how does it work in arbitration? And with us, we have the experts. As Jose Antonio said, Washington Arbitration Week likes to call on the experts, and now we have them. So to my immediate right is Brent Del Monte. He serves as the co-head of life sciences at BGR Group. He represents clients, particularly in life sciences companies, to help them achieve their objectives with regard to the federal government, the US federal government. He's worked for Senator Warner, Representative Bliley. He clerked for Judge Hilton and has been counsel to the House Committee on Energy and Commerce, where he had responsibility over food and drug related issues. He oversaw the enactment of several laws, which I don't fully understand, but I will read them.
Very important.
Medical User Fee Act, the Project BioShield Act, and the reauthorization, and this one I do know about, Best Pharmaceuticals for Children Act, and the Prescription Drug User Free Act, the PDUFA, PDUFA. He's also Senior Vice President for the Federal Government Relations at the Biotechnology Industry Organization, which has the great acronym BIO, where he successfully oversaw the enactment of priority legislation, more therapeutic project discovery tax credit, liability protections for bioterrorist and pandemic countermeasures, 2 reauthorizations of the other law that he did, the PDUFA. Does anyone call it that?
You nailed it.
Really?
Yes.
That's some acronym training, including important reforms on the accelerated approval pathway at the FDA, patent reforms, and 21st Century Cures initiative. So tuck in. To his right is Dr. Peter Rankin. He's a PhD economist in the life and chairs the life sciences practice at Charles River Associates. For more than 20 years, he's provided economic analysis and opinions involving disputes involving pharmaceutical, biotechnology, and medical device manufacturers. He has authored public and proprietary policy evaluation projects involving the healthcare reform reimbursement methodologies, antitrust exemptions, research and development initiatives, and research productivity. These are mouthfuls. That's part and parcel of life sciences, big words. He's served as an expert in litigation and arbitration, which is how we know him. He's testified many times before Congress. In arbitral disputes, he's often retained to assess the breakdown of development of commercial and commercialization agreements. And he has analyzed scores of agreements in the life sciences industry. That's what he'll be talking about today. And he'll discuss those terms and what they tend to require in international arbitration. And to his right is a woman who probably needs no introduction to those of us in Washington, Imani Chee. She co-chairs Covington's international arbitration practice and handles a wide variety of international commercial and investment treaty matters. She also, perhaps most importantly, I'll say most importantly, serves as counsel to Ukraine at the International Court of Justice, where she just received a very favorable ruling on provisional measures and is really doing international law a great service, and we thank her for that. Marnie's experience with life sciences disputes, however, dates back to her time as associate counsel at the Office of the USTR, the U.S. Trade Representative. Since joining Covington, where she's of course a partner, she has handled high-profile investment treaty disputes, including probably the most famous pharmaceutical dispute in ISDS, the Eli Lilly versus Canada case, where she represented Eli Lilly, and has successfully arbitrated disputes under life sciences agreements, including a $1.8 billion trade secret claim, which we'll hopefully hear a little bit more about. She is, among many boards and associations, a member of the Council on Foreign Relations and is on the dispute settlement roster for the Central America Free Trade Agreement and the Korean-US Free Trade Agreement. So, experts. If you didn't get that, that's the headline. So let's start with Brent. Brent, I wonder if you could kind of set the scene for us. What are the laws? What are we talking about? How does it relate to U.S. regulatory oversight? And kind of we'll start peeling the onion about how those disputes happen.
Sure. Thank you very much. And I hope you all can hear me. And I hope this is a very informal setting, which I appreciate. I would say, let's have a good conversation. You may ask, well, then why did I bring notes to a conversation? And I would just note that I frequently do that with my wife as well. So I'm Brent M. I head the Health and Life Sciences practice at the BGR Group. We have the good fortune of representing a number of innovative drug, biologic, medical technology, medical device manufacturers. We have some insight into what they are looking for generally. And that is, of course, predictability and fairness in the regulation of their products. They lean in, they work with both Democrats and Republicans to ensure the predictability is a major factor, and also just ensuring that they know what to expect when they approach the FDA. I am a former FDA counsel at the House Energy and Commerce. I have a different take and viewpoint, but I think it's pertinent to the discussion that we're going to be having today about international arbitration, because what we've been seeing recently is the push on the behalf of many lawmakers to have to have things less internationally focused and more domestically focused in terms of our supply chain. There was a tremendous re-examination of the supply chain as we headed into the pandemic. There have been voices out there for some time who have urged a look at the supply chain, but I'll tell you, a once in 100-year pandemic will really spur the interest of folks. As we have this conversation, I can tell you generally another thing that life sciences companies care deeply about is a resilient supply chain, but also a redundant supply chain, because whether it be a pandemic or a natural disaster or just a breakdown at a facility, which is of great importance to the production of a certain therapeutic or vaccine, you need to have supply chains, a supply chain with many different components to it. So the notion of, well, let's just bring everything back to the United States doesn't make sense, because you need to be located in very many different places to ensure resiliency and redundancy. Now, that's not to say that we shouldn't be trying to do more in the United States, because one thing the pandemic has shown us is there are a number of components to therapeutics and vaccines and medical devices which are manufactured elsewhere that really a pandemic can create shortages, things that we do not want. But we know for a fact that the Biden administration has taken resiliency of the supply chain as a top priority. One of their first executive orders early on in the Biden presidency commanded a number of different agencies and departments to give a look at the supply chain. It was America's Supply Chains was the name of the executive order. And HHS was told to look at pharmaceutical and medical device and vaccine resiliency, which they subsequently did. And earlier this year, they reported back and they talk about the types of investments which have been made during the pandemic of more than $4 billion to help the manufacturing of, whether it be API, active pharmaceutical ingredients, or key starting materials, up to finished dosage, finish and fill formulations. They wanted to have more of that being done in the United States. And they did put out billions of dollars. And frankly, they were pretty wise in investments. So that has been going on. Additionally, earlier this year, the Biden administration put out an executive order which focused, in some part, it was entitled Advancing Biotechnology and Biomanufacturing, their executive order. And what they did is they commanded the White House to have a series of meetings between industry and regulators to talk about what more could be done. And as part of this executive order, they told the Department of Defense to spend another $1 billion, I believe it is, to catalyze the establishment of the domestic and bioindustrial manufacturing base. So all of this money is going out the door to bolster domestic manufacturing. Again, trying to bring things back to the United States. At the same time, there have been certain regulatory tools that FDA has been employing to try to address shortages and try to encourage domestic manufacture, one of which is advanced manufacturing technologies. They have an office at the FDA, the Emerging Technologies Program, which is looking at these technologies which make it cheaper to and easier, not easier, cheaper to manufacture in the United States. Things like continuous manufacturing, 3D manufacturing, certain types of other platform technologies, which can provide for more predictability and more round-the-clock manufacture to address drug shortages, and having that being done in the United States. So there has been an all-of-government approach to onshoring to the greatest extent practicable. At the same time, the Congress has been spending a heck of a lot of time focused on this issue. And at the beginning of the pandemic, there were some really, I'll use a technical term, crazy ideas which were being proposed, such as, you can't sell in the United States unless all the components and the finished dosage forms, et cetera, are being made in the United States. You can't sell to, the largest purchaser of drugs in the United States and medical technology and the like, or user at least, is the federal government through the Medicare and Medicaid programs, VA health, defense health, et cetera. And some were saying, well, government can't purchase unless it's made. That's entirely impracticable. And fortunately, ideas like that were not ultimately pursued. But instead, as we are in a, you nailed it, UFA year, there is the User Fee Acts, there's medical device, there's prescription drug, et cetera. They have been taking efforts to encourage, again, domestic manufacture. Senators Murray and Senator Burr have a bill which is under consideration right now, which would empower the federal government to set aside certain manufacturing rights in the case of a pandemic. It's called warm-based manufacturing. That's under consideration right now. And again, on both the House and the Senate side, there is the consideration of a pilot program on advanced manufacturing technologies, wherein for the first time, manufacturers would be able to seek a designation that their technology itself, divorced from the consideration of an application, but rather their technology could be designated so that in the future, other third parties that they license with, can use that technology and rely upon that technology, and FDA would give priority to the review of the product made with that technology. All under consideration right now. But I guess the punchline, which, and I've been repetitive, so you should get it, is the fact that while not on international arbitration itself, impacting it is the desire that many folks, many lawmakers want to bring things back to the United States. Not at the exclusion of international, but future manufacturing capacity.
Thanks, Brent. That's exceptionally helpful. I didn't realize it was an UFA year. Now we know, and we can roll that out to our clients. I mean, I do think, just to kind of continue to contextualize this, it is exceptionally important that as lawyers we do more of this, where we get a sense of what the kind of industry and the regulatory oversight of that industry is providing for, so that we can anticipate as ADR professionals disputes and help our clients resolve those disputes before they arise, right? I mean, that's when we show value as arbitration practitioners. It's in that. It's keeping disputes from courts and ensuring we do our best to resolve those disputes before they happen. So that's very helpful. I have lots of questions about supply chain redundancies and things, but we'll save those for after we hear from Peter. Peter is going to tell us, in an UFA year with all of this onshoring activity, how are you seeing this manifest itself in deals?
So as a caveat, I may be the only one in the room who is not an attorney. I'm an economist by training. I work at a consultancy. And as Patrick said, I lead our litigation group. But I think one of the things that's interesting context is our litigation group is actually the smallest piece of what we do in life sciences. Most of my colleagues are strategy consultants. So they are retained by pharmaceutical manufacturers, biotech, medical device, diagnostics, to help them deal with business realities, how to launch a product, how to anticipate changes that may happen governmentally. We also have a policy group that looks at different proposed legislation and works with the trade organizations like Bio, Pharma, FPI, FPMA. So in that context, most of my colleagues are out there really wrestling with how manufacturers go about bringing therapies to clients, bringing devices to clients. Not shockingly to those involved in life sciences, the real key to life sciences, the lifeblood, is innovation and finding new ideas for new therapies. That's where the scarcity is. As an economist, that's what I look for. Where's the scarcity? It's the ideas. It's what can we develop into a new therapy. That makes intellectual property protections critically important. Trade secrets, patents, every form of intellectual property protection. And so when in the context of disputes, we see what's happening most recently, there is a real dire effort right now to try to properly protect and value early stage intellectual property, even before it's a patent, when it's a trade secret. You have a great idea for a new genetic therapy, but at best, if everything breaks right, 20 years until commercialization, and a lot of clinical testing between now and then, and a lot of production issues to work out. So what happens if your collaboration partner makes light-fingered use of assets that were involved in the collaboration agreement? How do you value that? We know in litigation it's very, very difficult. Right? In the context of litigation, the standard for damages, if you're harmed, is it can't be speculative. Well, definitionally, we're talking about IP that's, if it's pre-stage 1, it's got what, a 8% chance of ever being embodied in a commercialized product. And then you've got all the pricing issues to deal with. There's a long, long road ahead. And so courts have said, I feel bad for you, but you can't give me a non-speculative damages amount.
Can you tell us what light-fingered use is?
There's many examples. I don't want to get myself into trouble, but it's often the case that there are so many different aspects to developing, even before you get to commercializing, but developing a new therapeutic target, that lots of different parties are involved. And so there's licensing with production specialists, with different types of scientists. You might have to run clinical trials in other countries, which involves sharing protocols with folks who might be key opinion leaders and working, have relationships with other manufacturers, and suddenly you see something that looks stunningly like your protocol being run for a product that's not yours. And there's a slight suspicion that you may have been the author of that, even if you would have preferred not. And so, what we see really in commercial arbitration recently is kind of two themes. And the first is, how do you protect, how do you value, what kind of road marks can you put down to value early stage IP in case your trade secrets wander? If you can't point to a revenue stream of an eventually commercialized product, what can you point to? And what we've seen in a lot of contracts is looking at valuation of timelines. If it is the case that this trade secret allowed you a 6-month leap in your protocol development, what does that 6 months translate to? And look, there's still lots of discounting, because we know that saving 6 months pre-stage 1 doesn't mean you're launching 6 months early. There's a lot of regulatory and development vicissitudes between the event and the realization. But it's still a landmark. There's also a fairly vibrant investment banking community. And so if people are willing to make bids on early stage research, that's at least markers in the environment that can be looked at in terms of valuing some of that early stage technology. And often in life sciences, what we go to is comparables. Well, there's got to be something like this. But companies don't like to think about comparables, right? You've got a first-in-class therapy. You've got something revolutionary. The last thing you want to do, especially early on, is say, but it's like this other product. Or if you look at this one, that will give you a good road mark. Because the whole point is that you're going to have something new. You're going to help patients in a fundamentally novel manner. And to suggest that there's a benchmark devalues you from the start. The second development that we've seen in the commercial side of international arbitration is really what I call wrestling with efforts clauses. There are hundreds, thousands, many collaboration agreements between partners that are trying to develop or commercialize a product. And usually these contracts require effort. Right, I'm licensing my idea to you because you've got the manufacturing wherewithal to get it where it needs to be, and so I'm entrusting you to bring that product through the development process. I don't know exactly what that is going to entail, and you might have some idea, but you don't know exactly. It's a new therapy. We need to see how the clinicals come in. And so what the contracts need is some mechanism by which to make sure that our interests are aligned and that you're doing your job. And so typically there is an efforts clause in these. And there's all sorts of different phrases: diligent efforts, best efforts, commercially reasonable efforts, something to guide and to guarantee that the right amount of focus is going to be put on a developmental target. The problem is, as we know in life sciences, most ideas fail, right? They don't make it through clinicals. The ones that do often don't live up to their commercial expectations. And so at the end, in hindsight, you might say, well, this isn't what I thought I was going to get. Is that because of inherent characteristics of the drug, or is that because my development partner mishandled something along the way? And with genomics, with biologics, gene therapies, it seems like there's inevitably more and more people at the party, everybody bringing a little piece. And so if things don't work exactly to expectations, there's much more conflict about whether or not people did what they ought to have done along the way. We're also learning in the context of international arbitration, some national legal systems have a deep history in efforts clauses and phrases, and some have none. And so contracting parties come from asymmetric backgrounds, and a phrase like best efforts might mean something very particular to someone from the UK or America and mean nothing other than two words hooked together to someone from France. And so we've seen some conflicts arise from a simple definition that didn't have the foundation. And I shouldn't, we talk sometimes about physician-induced demand. I shouldn't badmouth these. I mean, I am an expert. We're retained to come in and kind of address these ambiguities, these vagaries from the contracts. But there are sometimes some odd breakdowns at the start just because the language is different. Recently, there's been a couple additional developments that put extra emphasis on efforts or extra stress. The first, which Brent probably can tell you much more about than I can, is these contracts are signed years in advance and things change. Most recently in the United States, we have the Inflation Reduction Act, which passed with surprisingly little fanfare attention-wise, but has massive implications for pharmaceutical pricing in the United States, and massive implications in a way that isn't quite yet defined. We don't know what specific drugs are going to be targeted for price negotiations with Medicare. We don't know how that's going to affect other products in that therapeutic class. And we don't know how a party operating under a best efforts clause to price a product now has to redo the calculus for fear of being swept up in the IRA's changes to the pharmaceutical pricing. We also have had recent run-ins with public policy considerations, not particular policies, but with an in-licensing manufacturer who said, we don't ever want to have the most expensive therapy in a therapeutic class. As a company, that's just a position we want to take. But is that commercially reasonable? Did a partner licensing a product to them want anything other than profit maximization? That partner just wants the revenue. They don't really care about the corporate reputation or the policy stance being taken by the in-licenser. And finally, what we see a lot in the biotech world is what they call biobucks, big deals with lots and lots of value. I just signed a $1 billion contract, and $950 million of that is in milestones that the stars have to perfectly align to come to fruition. Does the existence of milestones imply the need to pursue them? Or is it commercially reasonable for an in-licenser to look at that milestone and say that's crazy? That's outside the bounds of what we would typically do for a product like this. And so if it happens, we'll meet the milestone, but we don't put any special effort into achieving the milestone. Switching gears quickly to the investor state side, life sciences hasn't really been, we have notable cases, and I don't want to steal Marnie's thunder, but there are other industries that have been more vibrantly at the center of investor state arbitrations. We've had our big hits. There's probably about 20 cases since 2000 involving pharmaceuticals or pharmaceutical manufacturers. We are ripe for these kind of disputes, right? Pharmaceuticals, biotech, medical devices have very high priced cost margins. They have a lot of sunk development costs. And so by the time you have a product, everything's invested. And that makes potential opportunistic activity or behavior by states more likely. There are two particular factors that make us think we're going to see more investor state action here. The first is the patent regime scrutiny as states seek products at lower costs. I don't want to dwell. We've heard a lot about the pandemic, but this is the category into which compulsory licensing would fall. And I've talked to folks who have said compulsory licensing will never happen. If it didn't happen during a global pandemic, when would it ever happen? I guess I don't quite subscribe to that view. Just because the first attempt at something didn't come to fruition doesn't mean that the people who wanted it to happen are going to give up. And there's some slight irony that the World Conference at which compulsory licensing and patent waivers was to have been discussed almost this time last year had to be canceled because of the Omicron breakout. But the demand is still there. The economic situations supporting arguments for taking a hard look at patent waivers and compulsory licensing remain. And so I don't think the fact that it didn't happen during the pandemic means that it won't. The last bit I'll mention is that there's an increasing focus on manufacturing. We certainly heard domestic manufacturing from Brent, but as we deal with biologics, gene therapies, autologous therapies, getting the manufacturing process right is very difficult. It involves a lot of IP, it involves a lot of partners, and if you want to have a redundant and resilient process, it involves a lot of different jurisdictions. That means manufacturers are building up very defined assets in different parts of the world, and those are the kind of assets that tend to get involved in investor state actions. There may have only been roughly 20 in the last 20 years, not even that, but almost half of them were state seizures of distribution or manufacturing assets in local countries. And so with an emphasis on manufacturing, that can only increase. I had more, but I think I've gone over time, so I'm going to turn it over to Marnie.
No worries, Peter. Thank you so much. That was very, very comprehensive and helpful. I think there's a lot for us in the kind of discussion portion to untangle here. But I think one of the many headlines that you gave us was early thinking about IP protections are important. I think you also gave us a headline about clash of legal cultures and what these phrases in contracts may or may not mean. And also thinking through kind of domestic and offshore manufacturing conflicts. All of those things, if you're playing at home, are ripe for disputes. And now we have no better person to tell us about how these disputes manifest and how we can protect ourselves than Marnie. So take it away, Marnie.
Thanks, Patrick. I think Peter and Brent did a really good job setting the stage for why we as lawyers have a lot of strategic advising to do in this area early, assuming that there may be a dispute down the road. As Brent mentioned, I mean, really cross-border kind of collaboration and development in life sciences has really become the norm. And I don't think that's a trend that's going to reverse. And so because you have a lot of cross-border collaboration and development, life sciences companies are increasingly looking to arbitration clauses in their agreements where they're not going to be able to reach agreement on submitting certain disputes to a particular court. If you're a US company and you've entered into a collaboration agreement with China, you may very well agree to an arbitration provision. Certainly, you likely don't want to find yourself in the Chinese courts, and there may be certain reasons why the Chinese party doesn't want to litigate here. So it goes back to kind of one of those fundamental tenets as to why we have international arbitration. And I think as we see an increasing number of these disputes, which everyone's referenced, it's really some of the same general principles that we've seen across industries. But this industry in particular is kind of globalizing and going cross-border maybe a bit later than some others. So with that, I thought that as the lawyer on the panel, in addition to Patrick, who I'm sure will provide some insights as well, I could talk a bit about some of the legal strategic considerations given this great scene setting that we've had from Brent and Peter. And I think I'd pick up where Brent left off on the importance of intellectual property. For life sciences companies, that really is where your value is. And so when you're drafting your disputes resolution clause in the very first instance in your contract, companies do think about their IP, and their IP often, drives the decision on how they see any future disputes being decided. So, just a couple of strategic considerations. First is the question of whether IP disputes or patent disputes in particular are going to be in arbitration or out. And you certainly see a lot of dispute provisions which say, well, for this collaboration agreement, we'll agree to arbitrate disputes, but there's a clear carve out for IP disputes, or there's a clear carve out for patent disputes. And I'll mention that, come back to that in a moment. But I'm sure, as Brent could also attest, when you have one of these IP carve outs, which is not uncommon, it can lead to a lot of legal complexity. It is often hard in these commercialization agreements or collaboration agreements to figure out which provisions of that agreement, if someone alleges breach, are related to IP or are about valid IP. So the words you choose to do that kind of carve out are really going to matter, whether you're in arbitration or you're in courts. And even if you choose your words carefully, it can often be very complex. The second is a lot of life sciences players are repeat collaborators. They work together on one strand of research, but then they may see an opportunity to collaborate on a different stream of research. And so because of that, while some of these are going to be bet the company cases, particularly for the smaller partner, if there's a differential between the size of the two parties, in other cases, these parties do see themselves as wanting to get through this particular dispute because there may be collaboration opportunities later. So it very much has the flavor of a more traditional commercial arbitration, at least in some cases, where you don't really want scorched earth because it may be that some other part of your company sees another collaboration opportunity with this particular partner. And the way life sciences companies tend to be structured, there's kind of different people responsible for business development, different people over here protecting IP, different people over here drafting the agreement. So they all need to be talking to each other within the company. And that's an important strategic role for an outside lawyer as well, to make sure that the lawyers you're working with aren't just thinking about their lane, but are thinking about the other lanes that could get dragged into any future dispute. So for example, you will often see like tiered dispute resolution clauses that try to resolve these disputes through negotiation before you might get to an arbitration, for example. And then, I mean, they don't always work, but certainly it's something that a lot of collaborators, because to enter these collaboration agreements, you start out, you're feeling really positive. You've got this great synergy. You're hoping it's going to be a blockbuster product. So of course you're going to work everything out. And then the third point I'd mention as a strategic consideration is considering whether there's a way to avail yourself of investment treaty protection. Certainly, most investment treaties either explicitly or implicitly protect intellectual property as a protected investment. And particularly for a larger multinational who may have a fairly complex ownership structure to begin with various parts of their business distributed in different regions throughout the world, I think it's quite reasonable, particularly if you're entering into an agreement with a party in a developing country market or a market that doesn't have as developed or strong IP protections, that you do consider investment treaty protection in terms of which party is actually going to sign the agreement. And to some of the points that Brent made and Patrick made as well, we certainly have seen, and Peter as well, we certainly have seen examples where it's really the government that steps in and takes some kind of unfair, discriminatory action, something that might amount to and expropriation, where having that extra layer of investment treaty protection is helpful on the investment treaty side of things. So let me just talk in a tad more detail. I'll still keep it fairly high level about these IP disputes carve-outs. At least as practitioners at Covington, my colleagues and I have found that these IP carve-outs often don't quite work as intended. It often depends on how litigious, I suppose, the parties are. Oops, excuse me. It's not COVID. I tested this morning. Okay. Well, that just made me cough more. But often, for example, patent disputes might be carved out, which means you're going to arbitrate trade secrets disputes. You're going to arbitrate other kinds of IP disputes. But patent disputes are going, say, to the US courts. That is often much harder to implement in practice than it is when written on paper. So take, for example, a carve out that's only specific to patents and not all IP related disputes. We handled a case that was a trade secrets arbitration. This was the $1.8 billion trade secrets arbitration. I would say that the value they were putting on that arbitration really was valuing the trade secrets like as if they were patented, right? But in the context also of that trade secrets arbitration, there was a lot of document disclosure, cross-examination that really went to a future patent dispute that hadn't happened yet, which was going to happen in the US federal courts. While at the same time, there was a legitimate trade secrets claim that was also being arbitrated because the trade secrets weren't carved out of the arbitration clause. In that case, again, strategically thinking as an international arbitration practitioner, we had patent lawyers. I mean, in addition to some folks who know trade secrets, and I know enough IP to be dangerous, but I had patent lawyers on my team because every time anybody said anything, it had huge billion-dollar ramifications for my clients' patents. And you're not necessarily going to know that. So knowing like the type of dispute you're working with in the international arbitration context and what the spillover effects might be if you have, one of these carve-outs is important. Similarly, the relationship between if you have a more general carve-out, we had another case where it carved out kind of IP disputes, and what was being arbitrated really were the commercial clauses of the contract, issues related to, best efforts, etc. But did they have an IP component? And so we were arbitrating a dispute, but the other party ran to court and said, no, the arbitration should be stayed and these matters should be litigated because they relate to IP. So again, you're back talking about the scope of the arbitration clause, the precise language of the carve out, what's supposed to be arbitrated and what is not. So when these corporate deals are done, I mean, I know this is just kind of one of those common adages that no one pays any attention to the disputes clause because they're just excited about their deal. At the 11th hour, your phone rings and someone asks you to, thank you, look at the disputes clause before they sign. But particularly where there are these carve outs, as Peter was mentioning, it can really be very, very complex. And I think I'll leave the best efforts issues to maybe the discussion that comes afterwards. But even these just, commercial arbitrations that focus on these best efforts clauses can be very complex. Like what's the governing law? What's the understanding of the best efforts provision? And some of those can bleed into IP. So there's really a lot of strategic considerations upfront in anticipating what type of dispute you can have. And then once you actually have that dispute, there's also a lot of strategic considerations to consider how the dispute you're arbitrating may have ramifications for the IP that's held by your client more generally. So, IP really, I've found at least, is really core to these disputes, even if the arbitration isn't on its face technically about the intellectual property. So I would just make a few final observations. Um, One is that, well, let me say one thing about best efforts in this problem, which is that, define the term in your agreement. That can be helpful. Certainly, the UK and US law is quite developed on this. So if you agree to define the terms best efforts, you might be in a better spot. So that's, one way to deal with it. And so finally, in addition to thinking about these strategic considerations, both pre-arbitration and once you're in the arbitration, I think thinking about the investment treaty arbitration is also quite important. Many of these cases are just going to be either or. Either it's clearly a commercial arbitration between private parties, or there's some regulatory, issue where there's concern that it's affected essentially a taking or expropriation of intellectual property, where there's maybe been discrimination or a potential national treatment violation or a fair and equitable treatment violation through the regulatory process. And all of these things, I think, also need to be top of mind, given, as Brent explained, that this is a highly regulated environment. And in a lot of markets, that highly regulated environment is an industrial policy tool for countries. And because it's an industrial policy tool, you might find that your life sciences client might, run into discriminatory issues, issues that are arbitrary or, don't provide the kind of like regulatory review that should be required, or even could do so much to pass a regulation or adopt a law that diminishes the value of IP so much that it would essentially affect an expropriation of the IP, or a compulsory license where if the compulsory license isn't done kind of in accordance in international rules and that provides for fair compensation, then there also could be issues. So there's a whole host of issues in the regulatory space that can lead to investment treaty arbitrations in addition to commercial ones. So there's a lot here. There's a lot going on. And I think I would say our definite consensus is these disputes, as Patrick mentioned, certainly aren't going away anytime soon. And if anything, we may see more of them because there was a lot of quick agreements made during the kind of COVID phase. So back to you, Patrick.
Thank you, Marnie. That was very, very impressive. Obviously, one of the takeaways, if you haven't heard it already, is there's a lot here, right? Another takeaway, perhaps, is for those of you who work as practitioners alongside patent lawyers, go home, say, hey, I'm an arbitration practitioner. We should collaborate more because there's a lot of work that we can do for our clients together. That obviously is definitely a theme, and certainly one that if you want to get involved in avoiding a dispute is essential. Let me kick off the kind of question phase with a question I think for Brent and Peter and Marnie, if you want to jump in here too. What's the view? We've heard a lot about the US, right? And this concept of onshoring, the kind of pandemic, I don't want to use the word threat, the pandemic policy thoughts about compulsory licenses for things, the public health related issues. But obviously Europe is also quite a substantial and robust innovative market. And we haven't heard anything about what they're doing. It would be interesting to kind of get a sense from a European perspective or any other innovative market, what you're seeing there, and then maybe we'll broaden it up a little bit and get back to disputes.
Well, thank you. And I would just note, we can, and we do tease a little bit us FDA people with all of our acronyms. And you mentioned the granddaddy of all the user fee acts, which is prescription drug. And since the creation of that user fee act, I believe it was 1992, you've had other regulated industries have user fee acts adopted as well. Generic drug user fee, medical device user fee, biosimilar user fee, all up for reauthorization this year. And then there are a couple animal drug user fees for next year. And the notion behind this, these acts is 30 years ago, you would see country of first introduction or area of first introduction of new therapies be Europe. There was a case made that the FDA was taking too long to adopt new therapies, and it was a better idea on behalf of manufacturers, they thought, to go to Europe and seek approval and then have these products in the hands of Europeans prior than Americans due to the lack of predictability at the FDA. And what the user fee acts have done over that time is manufacturers will pay a fee for review of their application and the products that they have on the market and facilities. And in exchange for that, the FDA will commit to reviewing therapies overall much more quickly, not unsafely, but just in a more diligent fashion. And in the 30 years since enactment of the Prescription Drug User Fee Act, you've seen the country of first introduction become the United States of America rather than in Europe. And this is and you've seen much more capital come into the United States, much more manufacturing come into the United States because FDA has become just as rigid in terms of safety demands as they always have been, but they've been given flexibilities as well. And they now are more appropriately resourced. And we've seen the therapies come to the benefit of the US citizens more so quickly than in Europe. Others can look at certain price controls that they have in Europe. And that is another reason you see much more investment in the United States. But when I speak to the companies I represent, they have no deep concern with EMEA, which is European body, their review of products, but they all agree that the United States, through the investments that they and the US government have made in the FDA and in regulations by the FDA and flexibility to the FDA, that it is a more predictable place and better place to first introduce their products.
Go USA.
I'll certainly echo that. What we see in the commercial behavior of our manufacturer clients is the PDUFA date is a landmark that is banked on for development, commercialization, investment reasons, and so there is that predictability. What I've seen more in looking at European, at least on the commercial arbitration side, is in the U.S. we have the FDA for approval. In Europe, the approval is often rolled up with the reimbursement. And so it's often the case that a global manufacturer who wants to launch a therapy in multiple jurisdictions has to think hard about how to launch in Europe, what country to approach first, if it's going to go several at once, or if it's going to target the big five or start in a particular case. And it's been chaos, frankly, in that there's many examples where what was thought to be a kind of friendly environment to be a first outreach for Europe didn't end up being so. And it gets tied up in therapy gets tied up in reimbursement decisions, and suddenly the European launch as a whole is lagging. And again, it brings in all those questions about should that have been foreseeable or not, just because we don't have the same kind of predictability that Brent's worked so diligently on.
Well, as disputes lawyers, we thrive on chaos. So that's good.
I might add one observation on the EU market. I mean, a lot of international arbitrations in the life sciences space are like US, Europe. There's plenty of small players in the US who collaborate with some of the European giants in this space. And similarly, a lot of smaller biotech firms in the EU that collaborate with some of the big US companies. So there are a lot of commercial disputes across the Atlantic. In terms of predictability, one thing I would say is the mention of compulsory licensing. There have been throughout COVID discussions in the World Trade Organization as to whether or not there should be kind of a broad waiver to issue compulsory licenses for patents for COVID vaccines. And then an additional debate related to therapeutics and diagnostics for COVID. There, and kind of what you might refer to as the international regulatory space, the EU has actually really been kind of at the forefront of trying to take that slowly, making sure that there's actually a case for compulsory licensing, and essentially being like the defender of, IP in this very innovative, cutting edge area, noting that there's other ways to make sure that vaccines, et cetera, can get distributed to those who need them without eroding IP rights. And it's really been the EU, not so much the US, that's been out in front there.
Let me, please.
Yeah. Great point, because that has been the case. I can say, I spent time on a hill, and when you're on the hill, you think you know everything. It turns out you don't know anything. And then I went to regulated industry at Bio, where I was the head lobbyist at Bio, and I did get to meet with a number of CEOs and other leaders in the biotechnology field. And just to underscore the points that are being made, nothing, the lifeblood of the biotechnology and life sciences industry is intellectual property. It's by far the most important thing. It allows you, with strong patents and certain patents, to go out there, and as well, FDA granted exclusivity. That's a whole different things, but that's another protection that from FDA to not agree to approve a competitive product, a generic product for a certain period of time. But that's what allows life sciences companies of all sizes to go out and get the capital that they need to go down the path of trying to commercialize a product over the course of 10, 15, 20 years. And these threats to life sciences, whether they be the international ones Marty just mentioned, or margin rights under by Dole Act in the United States, that these are threats which unfortunately come up every now and then, which really are of the gravest concerns, because the only way that folks are going to invest the billions of dollars necessary to develop new therapeutics is with the assurance that they can protect these from competition for a period of time. And if you then have, whether the domestic US government or international government saying, no, we'll just let someone come in and start manufacturing that because of X, Y, or Z, that really is chilling to investment in life sciences.
Well, I like the continued use of lifeblood, since we are talking about life sciences. We did hear a lot about the kind of concern about exclusivity periods, and we haven't even invoked Hatch-Waxman, but we'll come back to that perhaps. Two things just to throw out on the table so that folks can pick it up and talk about it is we haven't really spoken about generics in this space, and the other thing we haven't really chatted about is, and I know Marnie can probably speak to this too, is the exclusivity periods or the kind of IP protections in some of the multinational big treaties, right? So there was a lot of criticism back when the United States was a signatory of the TPP about the protection that the United States helped broker in the IP space, and as one of the leading innovative markets in the world, probably a lot of your clients, Brent, were not thrilled with what the United States provided for in that agreement. So we can talk a little bit about that too. Let me just shift gears for a second and talk about trade secrets. And go back to basics. You are a lawyer too. Go back to basics. And those basics are arbitration requires privity, right? And when someone steals or is attempting to steal your IP and there's a trade secret issue, you don't always have direct privity with that person. Like I'm thinking about a rogue employee or something else. So how do we get around those tricky little issues in the trade secrets space? Anyone want to handle that? These were not pre-planned questions. If that's too much of a stumper or it's improperly phrased, do let me know. Brent, go first. There it is.
My point is I'm not competent to answer
Aha. Okay. Well, that bought enough time for the most competent person on the panel to answer it.
In my experience, that hasn't actually really been an issue, in that it's been kind of a company to company, you stole our trade secrets allegation. And even if it's pinned on which specific, actors might have done the stealing, really that the companies are responsible for the actions of their employees. So it hasn't actually, manifested itself. Now, what I could see because of the interaction between these international arbitrations and litigation is you could see a situation where, company A sues company B, for because their rogue employee, took the trade secrets of company A and then left and started company C or something like that. And company B is like a better target. You could see some then parallel litigation where company B sues its former employee. So I think it could spin off into other kind of parallel litigation tracks. And I have seen, situations where, again, going to the messiness of these carve outs where, if you have a trade secrets litigation, but it's really kind of a patent dispute disguised as a trade secrets litigation, then maybe you could go to court and get like a declaratory judgment that you didn't infringe the patent or something like that. That would run in parallel. So I think you could have parallel litigation against the rogue employee if that's truly the case. I think there'd then be, not only do you have to consult your patent colleagues, but you have to consult your employment law colleagues as to like when you're responsible for the rogue employee or whether you have some kind of defense. So I think it could play in, but I think it would be a litigated and contested issue because in my experience, the company's responsible for the trade secret theft in terms of the allegations. And so, but it also, I guess the last thing I would say is if it is truly that, it may be a dispute that's resolved short of completing the arbitration if the parties investigate.
Well, Marnie, you anticipated the exact factual scenario that I've litigated. I mean, we had a situation under a licensing agreement that we alleged there was a patent infringement. That infringement case went forward in the kind of U.S. courts, but in parallel, there was the possibility because of a drafted arbitration clause in the licensing agreement to bring a parallel arbitration on different issues. And it was actually the threat of the arbitration that resolved the overall dispute because the patent courts were taking a while and it's too high risk for both parties to have a disposition on the patent. And the real issue was the potential improper use of the product under the licensing agreement, which was resolved through the threat of arbitration and imminent damage, which was going to go a lot quicker. So arbitration is a tool in the kind of, let's say, more kind of prosaic litigation strategy that a lot of our clients are going to be interested in. Another question I had, and this one is, I guess, for Peter and Marnie, is, so you mentioned ISDS or investment treaty protections. What are the and compulsory licenses is certainly one of them, but what are the other kinds of state actions that could give rise to a dispute in this space? Just to kind of throw some of those out on the table.
Yeah, well, in the NAFTA dispute between Lilly and Canada, it had to do with the failure to provide patent protection in accordance with international standards and the standards that are in the treaty. It also can be on the regulatory side, where countries can grant regulatory approval to generics for products that are still protected by patents, and the interplay between the IP protections and the regulatory and data exclusivity protections there. And, it can, as I said, for me, in my experience, some of the investment treaty issues really are when IP kind of bleeds over into industrial policy. So, if there is a domestic champion that a company or that a country or their regulatory authorities are trying to help, particularly say, a generic company who would like to have access to some of the IP information that the government has because of the regulatory approval process, then there could be some misuse of that intellectual property that also could run afoul of investment treaty protection. So those are just some of the issues that come to mind. But you also, I know, have arbitrated in this area, so might have other thoughts.
Well, I just kind of one two-finger follow-up on that. Do you see governments laying claim to kind of some of the defenses that they might have with regard to public policy, essential security carve-outs during pandemics, things like that, playing a more ascendant role in investment disputes? Or do you, I mean, industrial policy tool sounds like a claimant's phrase. If you were representing a government, you could say, well, this is a matter of public policy and public health, and therefore it's not covered under the treaty.
Yeah. So I think the public policy exception, I mean, that would be my go-to. It's public health, it's public policy, and that is a go-to for many governments. And I think, it's the arbitrator's job to try to sort through, what is a legitimate public policy exception and what is not. So I think, yes, like that's an issue that will get litigated in almost any life sciences related investment treaty dispute, in my view, because it's available to say like, well, we needed to do this because it's in the public interest. But I think that is really the beginning of a conversation and scrutiny by the arbitrators, and not really an end point, because there may have been other ways to go about it. Was it done in a manner consistent with other IP obligations and international IP norms? So I think it kind of is the starting place, but not really the ending place. That would be my view. And national security, we can all probably have an opinion on that, but in my mind, it's not a good fit for this situation.
I guess I would just echo Marnie's comments. And we had a case involving a taking of a distribution network, and absolutely the first defense was public health. It's in the public good. That may be an easier argument to make when you're talking about maybe a gene therapy center or the site of a clinical trial. An established distribution network, it was a bit more difficult, and in that case, the arbitrators were fairly concerned about the legitimacy of a public policy defense from the start.
Yeah, well, I mean, is it public policy to try to onshore or force supply chains back onshore? There could be damage there to those folks who can do it with better margins offshore, and now are being forced to move forward. So let me see. We have about 10, 15 more minutes. If folks in the audience had any questions, don't be bashful. Yes, please. If we could get you a microphone. Oh, we have to use this one. Sorry.
Thank you for this.
Yeah, and that is a live mic. So
Great.
yeah, thank you.
Thank you for this.
And if you could just introduce yourself.
Sorry, I'm Lauren Blanchard from Kroll and Mooring. This has been a wonderfully orchestrated introduction to the topic. Forgive my ignorance. What is the purpose of carving out patent disputes in the dispute resolution clause?
Oh, Peter gave me the mic. Wait, is this on?
It's on.
Okay, Peter gave me the mic, but I'm sure he also has it on. Part of it is predictability and ensuring that you're in a court system that has just a long history of deciding patent disputes according to specific standards. Patents are also domestic protection for patents, so there's been litigated jurisdictions that have patents. So I think it really goes a lot with predictability and expertise. It's something I didn't mention at the beginning. Talk about strategic considerations. So one strategic consideration also in these disputes is who are your arbitrators, and whether you need arbitrators that have IP disputes background or life sciences background.
The mic's on, but I mean, they can hear us at home too, so that's good.
Oh, okay, and I can project. So in my mind, that is one of the issues. It's predictability, it's expertise, it's the fact that you have relied on, for your U.S. patent, you've relied on a certain set of U.S. standards in kind of patenting your product, and it's unless you've decided you're going to have like 3 patent experts as your arbitration panel who will be applying U.S. law, there's some risk. There's also no chance of appeal. And to use our favorite phrase, the lifeblood of these companies is IP. A lot of general counsels are quite wary of there being no appeal process with regards to litigating patents. So that's in my experience, but I'm sure Peter has some other observations.
I think my observations are very consistent. Even in the U.S., if you just look at litigation, there's a remarkable amount at the circuit court level of overruled IP decisions, and it's often the case that when we're involved in a dispute, from the start, the parties know that they're really positioning themselves for a later trial because in the first instance, they have a judge who isn't versed in the architecture of IP law and all the intricacies of the IP issues. And so they're really establishing a record. And I think you see the same thing in arbitration. It's really difficult to harken back to the keynote speaking about, finding arbitrators who both have the subject matter knowledge to arbitrate these disputes, are free of any kind of encumbrances that would make it inappropriate for them to hear them, and then you want them to be IP experts on top. That's a very, very tall order, and you might be able to find 3 people, and they might be able to schedule you in 2.5 years from now. It tends to really be a potential drag on the arbitration process. Not that I think it's a walk in the park trying to run a parallel arbitration with an IP carve out at the same time.
Yeah, and for investment treaty arbitration, you'd also want probably those arbitrators to have some familiarity with public international law and how to read a treaty. So layer that on top too. So if those of you who are looking to be a unicorn in this space, now you know what you need to get expert on, and then you'll get appointments. Other questions from the audience? So the mic on the table, you might not hear it in the room, but it is coming through at home. So if you can hear us, then we can use the mic on the table.
Yeah. Well, thank you very much for all the enlightenment that you have provided. I had a thought concerning what is becoming or has become a trend with respect to trade, which is trying everyone, perhaps led by the U.S. at some stage, but everyone is really trying to bring production onshore, and somehow require national produce or input, etc. And that made me think about the performance requirements that are in various free trade agreements, mostly those led by the U.S., but in general in free trade agreements, we don't have performance requirements in necessarily in the old model bilateral investment treaties, and that made me think whether or not for life sciences, because the issue of whether you're going to produce onshore or elsewhere in India or China, etc., comes to mind. Whether the network of investment treaties, including FTAs generally do, but those are not most of the bilateral investment treaties. Whether the network of investment treaties is really ready or provides the tools to prevent the performance requirements that one would see in other in free trade agreements, and whether that is a relevant issue for life sciences. So any takers on that?
Well, I mean, I do think that the majority of markets where you have this question posed, whether it be as an innovative market or a generic market, are in some ways at this point covered under one of the larger FTAs as the spaghetti bowl goes, and then the clever use of for greater certainty retroactively perhaps covers some of the first and second generation BITs. I'm not sure if that's directly responsive. It's an absolutely good point. I am not aware of the 20 cases that Peter mentioned that question is posed, but I do think that one of the interesting things will be how robust some of those FTAs that include some of these innovative concepts retroactively work backwards to handle some of the less robust bits. But I mean, this goes to a larger discussion about whether first and second generation bilateral investment treaties are going to survive over the next 10 years. My own suggestion is that it will be very difficult for them to persist, but that's just my view. Marnie?
Take this one because the virtual people were asking for that.
Okay, we've got the better microphone now. No, I agree. It's a very good question. I mean, I think on older bits, it really might depend on how it's implemented, because you could see it be implemented in a way that could give rise to some kind of national treatment or MFN claim, or maybe it's implemented like in a very kind of arbitrary way. So in my mind, it may be also even for older generation bits. I think there's a question, is there a gap? Or maybe depending on how it's implemented, you could still do something. But I do think that, to your point, I mean, right now, this idea of like onshoring as part of an industrial policy effort is something that everyone's doing. And I don't think like on the face of it, that itself would be a treaty violation. But I do think, to your point, like, well, how you do it, you need to be thinking about these international obligations. And I'm sure Brent can attest from his time on the Hill, whenever our Congress is considering these types of provisions, there's usually plenty of people up there kind of whispering in the ears of folks saying, hey, the US has a lot of international agreements on this topic that you probably should consider as you're drafting your legislation. So I imagine there's a way to do it that's consistent with those obligations, but there's probably also ways to do it that would be inconsistent.
Yeah, and Brent can tell us how well received the statement to Congress. There are a lot of international agreements on this topic. How well received that phrase is.
Oh yeah, they always like, ooh, okay, well then we won't touch it.
Yeah, absolutely. That's definitely been my experience as well. Any other questions from the audience? There's a question online. Excellent. Jose Antonio, would you like to be our online, the face of the online community?
So the question is from Laura Richardson, and it's to Peter. So there you go. Given the difficulties and inherent speculation required in quantifying damages in life sciences disputes, has there been any consideration or attempt to include liquidated damages clauses in life sciences commercial collaboration agreements for breaches of certain terms, and in parentheses, such as are common in construction agreements? Or, here's the second question, or are there unique features in the life sciences field that would not lend itself to liquidated damages clauses?
That's an excellent question. While he's getting the microphone, I'm sure the French are well versed in liquidated damages clauses. Speaking of kind of cross-cultural conflicts between innovators and other jurisdictions, now that you have the microphone, that was my segue.
I can't speak to the universe, but I've only infrequently come across attempts to introduce the concept of liquidated damages within a life sciences context. I think the challenges are typically that if you take, say, a trade secret misappropriation, where you've some of your clinical trial protocols are maybe being expropriated, there's still value, and the company doesn't want liquidated. What they want is to continue the development of their product, and usually to block the party that's misappropriated the assets. And so it's often the case that we find ourselves in a little bit of a difficult situation where we are retained to assess damages with the hope that it's irrelevant, because the real goal of the arbitration is to secure the IP, to secure the path forward, and to ensure that the kind of ancillary roads to investment remain open. And I think maybe that's the key, is that those in life sciences know that the product that comes to market sometimes bears a resemblance to what you thought you'd bring 20 years ago, but often the case it's that along the path you've found other opportunities, other therapeutic categories, other aspects of the product to be developed so that you have a therapy that's still valuable to patients, still commercially viable, but not exactly where you thought you'd end up.
And the question of whether the promised utility is needs to be specified has been litigated in our space, right?
And I would just add that, to Peter's point, I have clients who started down, who acquired assets which are decades old. You can still eligible for patent protections for the indication and the like, but like I can think of one which was a weight loss drug, which ultimately was brought to the market for pediatric epilepsy. You just never know where the science is going to lead you with products.
We have time for one more question. Don't be shy. Anything else online? Oh, one more question.
It's David Ingle from Allen Overy. Thank you for the panel. Just a question on potential threats to life sciences. It seems to me from what we've heard that this requires billions of dollars to be invested in an idea that's extremely likely to fail. I imagine it's much easier to get financing, to commit financing for this idea when you're in a monetary environment where sort of low interest rates, there's liquidity sloshing around, and also where the interest rate environment flatters the present day value of potential profits in 20 years' time. As we perhaps move out of that era where money is a lot more expensive and where you don't get those advantages, is that a huge threat? Are we going to see a reduction in innovation in the future? And also, is there the possibility that there'll be far more disputes? Typically we think when there's less money sloshing around, people can't get paid what they're expected to get paid, suddenly you get disputes. So is that a threat? Will that have the kind of impact that I'm asking about or not?
Let me start with something before we get to the litigation component or the arbitration component. Let me just start with thank you. It's not going to be good for the U.S. environment for the research and development into new therapies, vaccines, and the like by implementing on a number of drugs per year a price setting of a maximum fair price for a product, and then a negotiation downward on that price, which is going to be which is what is mandated by the Inflation Reduction Act. That the pharmaceutical industry, the biotechnology industry were very concerned, very opposed to the notion that the government's going to be directly negotiating on a subset of very important therapeutics, and they contend, and I agree with them, that this is going to lead to, unfortunately, less development. I've already seen one company indicate that they're not pursuing an indication, which they otherwise would, because they did not want to potentially, in a number of years, be subject to direct negotiation, which the Inflation Reduction Act calls for. So that is of great concern to life sciences community.
Yeah, I absolutely agree with Brent. In the short term, market conditions change, economic conditions change. Investment in life sciences remains relatively stable in light of pure economic factors. What really chills investment is significant outside action. Anything that chills the investment opportunity, or people who invest in life sciences know they're playing a long game. What they're concerned about is the time consistency problem of some significant change while they're kind of waiting for the fruits of that investment. All that said, it is certainly true, your second question, it is always the case that we see an uptick in disputes when economic conditions get tight. Back in 2018, in the it's hard to remember that there was a downturn economically before the pandemic, which kind of stole the headlines. But that was the most recent example we saw where the economy tightened up, and suddenly partners with whom you were quite happy to forge ahead with, now you're looking at askance, and And we see an uptick in arbitration, we see an uptick in patent disputes, and we see a large uptick in competition claims, where everybody's looking for, some other revenue stream or a way to reduce kind of an ongoing cost line.
Well, we are at time. So it falls to me to say, firstly, my lifeblood is coffee and lunch, and that will be served outside directly after this panel. But secondly, to thank this incredible panel, providing very in-depth insights into life sciences and how they relate to the arbitration. And thank you to you, our audience at home and here, for your patience. And of course, again, to Jose Antonio for inviting us all. So thank you very much.